But then we're talking about compliance, right? So we're talking about compliance and enforcement, and the end result potentially are sanctions. Okay, because you've seen from the different presentations on implementation and compliance that there is a variety of measures that could be taken by any implementation or compliance committee or body. Now, when we're talking about sanctions, and I have to say, this word is very rarely used in the context of MEAs. So even in the hardest of MEAs, you will hardly find the words penalty, sanctions. Usually the terms used are responses, measures, no? Because even with the implication that we're talking about harder measures, there is the reluctance to associate sanctions with the concept of punishment. But what are sanctions then? Essentially, they are stronger, more punitive measures that are taken under some of these MEAs when the party is found not to be in compliance with the treaty obligations, no? And these often relate to the suspension of rights and privileges. In other words, these are the actions that should hurt, no? If you can say that, or that bite. So when they talk about mechanisms that are toothless, they often mean these are mechanisms that don't have these sanctions. And there can be many reasons why a mechanism doesn't have sanctions. Maybe, I think someone was mentioning yesterday, maybe there is no right or privilege that is precious enough in that context to deprive a party of. That would then result in that party exerting efforts to return to compliance. Or it could be other reasons, no? So, and then I think the question came up in the beginning, you know, if you look at when Haro was describing the structure of compliance mechanisms, there is always a phrase either in what we call the enabling clause, so the main provision in the treaty or in the decision that implements it, that describes the nature of the implementation or compliance mechanism. So the question is, if some of the descriptors being used for that compliance or implementation mechanism, it is that it is facilitative and non-punitive, could that mechanism include sanctions? Maybe let's take each word in turn. So if you have a mechanism that is facilitative, is it conceptually possible for that mechanism to still have sanctions? What do you think? Yes? Mm-hmm. No? Why not?
Because it's facilitated in nature.
Okay. And you don't think that sanctions could facilitate compliance? No? Okay. Anybody disagree with that? Yeah. Mm-hmm. Anybody else? How about the term non-punitive? Could you call an implementation or compliance mechanism non-punitive and at the same time have sanctions? No? Mm-hmm. Yeah.
Depends on the nature of sanctions.
Yeah. Mm-hmm. Yeah. Because there is some disagreement as well as to what is, you know, a strong sanction. And I think it largely depends on the context as well. Because if sanctions are supposed to hurt and to bring a party into compliance, then it depends on what hurts in the context of a regime, right? Okay, so let's see. But I did check, because I checked, I mean, one of the examples we'll be looking at is the Kyoto Protocol. And if you look at the description of the compliance mechanism, facilitative is in the description, but non-punitive is not. And then if you look at the Paris Agreement, Article 15, non-punitive is there. So the big question is, can you have sanctions under the Paris Agreement compliance mechanism? That's for us to find out, right? So some examples. So we have CITES. We've talked about that, suspension of trade. So that's an example of a sanction. And then the Montreal Protocol, you also have suspension of privileges, as with CITES. And in the Kyoto Protocol, we also had, we talked about suspension of the right to trade the credits under the International Emissions Trading System. So just general examples of what sanctions we are talking about. Okay. But I guess the point I want to dwell on more is that even for the MEAs that have sanctions as an option, there are certain considerations. So it's usually at the end of a fairly long journey that the sanction is applied. So it's very rare that you would have a party coming before a compliance or implementation committee, or compliance committee, that is, that would be sanctioned right away. No, so there are many steps and considerations that a committee or a body that's looking into applying sanctions or recommending sanctions would be looking at. Haro was talking yesterday about the theory of compliance, right? Why is the party in non-compliance? So is the non-compliance intentional? If the non-compliance is intentional, so it's the party is capable clearly and objectively, but for some reason has chosen not to comply, then a committee is more likely to consider sanctions rather than in a situation where non-compliance is arising from a lack of capacity. No? So that's. And then the gravity of non-compliance. So first of all, how often has the party been in non-compliance? In the regimes where sanctions are applied, usually these sanctions are applied for cases of repeated non-compliance. So first offenders, normally, unless they've been in non-compliance for a very long period of time, they don't get sanctions right away. There's a scale. You get reminders, you enter into a dialogue with the secretariat, or you get assistance from a special expert team, and then maybe you will get a reminder, a sanction, and then it gets, the consequences become more and more severe. But if the non-compliance then persists, then at some point sanctions could be applied. Okay, and then what efforts has the party taken to avoid non-compliance? So there's also a difference. For example, if a party has taken no efforts versus a party that took efforts, but maybe there was an earthquake in that country that resulted in some catastrophe or some major meltdown of its computer system, those kinds of things. So it does make a difference. And also, as we said, how long has a party been in non-compliance? I believe, and Elisa can correct me if I'm wrong, like in CITES, there are parties who've been in non-compliance for years, right? 10 years or more than that, and then the committee starts to think about whether it is time at some point to apply sanctions or to recommend sanctions. Yeah. And then the treatment of other cases. As I said, one of the reasons why implementation and compliance mechanisms are contemplated is so that all parties to an agreement feel that there's a level playing field and everyone is being treated equally. So if there's been a case before where there was a severe case of non-compliance but no sanction was applied, then the committee or body that is looking into whether to apply sanctions would then look at the matter of fairness. So how similar was that case to this other case? And what would the perception, which is as important as the fact, be about the fairness of the system that is being applied? And what is the purpose of the sanction? Ultimately, even in the application of sanctions, the objective is to restore the party into compliance. So, if the sanction that is being contemplated is so severe that it would cripple the party and not enable it to come back to compliance, which is an argument I've heard from parties. They haven't always won that argument, but because you can have a measure that is so severe that it actually disables the party. So I guess parents would know. Maybe you apply punishments to your children that are a bit severe so they learn, but not so severe that they're scalded or then they turn into little rebels. So you have that to think about as well. And then, of course, you have to observe procedural safeguards, especially when you're applying sanctions. So clarity of procedure. And by this I mean the procedures of the body that will apply the sanction or recommend the sanction. Because you see, in most cases, usually the body that is evaluating the case doesn't make the final decision. When it gets to a sanction, they usually have to make a recommendation to a higher body. Again, the exception, the Kyoto Protocol. But the clarity of the procedure, step by step. What are the steps? Haro showed you yesterday an illustration of how it is in the Montreal Protocol. what are the periods allowed for a party to do this, when does this happen, which body deals with that, etc. So that's clarity, including clarity of the procedure of decision making and safeguards there. For example, if there's a decision making process where consensus is the goal, but there is a voting procedure, the voting majorities should be such as to assure the party that would be subject to sanctions that the decision to recommend or apply sanctions is not taken very lightly. Yeah, so we're not talking about simple majority. For example, in the enforcement branch of the compliance committee, it's a double majority to suspend any party. So you have to have 3/4 of the entire branch, so that's 8 of them, agreeing to apply sanctions.
Deliberate. So transparency, and transparency in the decisions taken themselves. So if you were reading a decision, is the procedure that led to the recommendation of a sanction or to the decision to apply a sanction, is that clear? Are the facts on which the decision was taken clear? Are the legal bases for taking that decision clear? And I have to say that here, scholars have criticized the decisions of the enforcement branch of the compliance committee, because unlike other committees, for instance, the Aarhus Convention Compliance Committee, I think that has much lengthier and more detailed decisions. The reports of the compliance committee of the enforcement branch of the Kyoto Protocol tend to be shorter. So can you actually understand as an independent observer why the committee or the group got to the decision or the conclusion that it got to? And then very important, due process right. If any information, expert opinion, or document is being evaluated by this body, is the party that will be subject to sanctions then entitled to evaluate the same information? So first of all, it has the right to know what information, what documents, what expert opinion is being considered, and then it has the right to evaluate that, okay? And the right to respond. So the party has a right then to appeal to the COP when it's looking at that recommendation and to be heard. Right? In the case of a committee like the Kyoto Protocol Compliance Committee, where the decision to apply a sanction is made by the committee itself, there is the right to appeal that decision. Whether it's an effective remedy because you're going from a technical body to a political body is another matter, but procedurally there is the right to appeal or to review the recommendation.